I'm Jackie Hudkins, here together with my business partner, Candice O'Neill, and we're both attorneys licensed in New Hampshire and Massachusetts. My practice focuses squarely on real estate, and Candice focuses on corporate law and estate planning. And it's amazing how these two practices converge and really work together on a very routine basis. So this summer in particular, we had a lot of sellers come to us prior to closing, and believe it or not, they thought that they owned their properties through inheritance, but in fact, there was an important step that the family hadn't taken, and they couldn't sell until they went through the probate process. And so what happened is the real estate closings were all delayed. And in order to prevent this type of delay and the expense of probate, Candice has the solution.
Sure. So the best case scenario is to move your property into a revocable trust prior to your passing so that later, after you've passed and family members want to sell a property, there is no court involvement. The successor trustee has typically immediate access to the assets and control over the assets, and there's no waiting period. Unlike with a probate administration, which can take several weeks, even months, depending on the court, in terms of who even has authority to enter into a purchase and sale agreement or complete a closing.
And even a listing agreement. So believe it or not, often realtors fall into a trap. They meet with a family, and the children of the deceased parents might believe that they have inherited the property, and they move forward and they sign a listing agreement with an agent to sell their parents' home, when in fact they didn't even have the legal authority to sign that document. So it's not really even binding, valid, or enforceable. Then they take the next step of actually signing a purchase and sale agreement. This happened in our practice this summer. They'll sign a purchase and sale agreement. The buyer then expects a timely closing, and they start tolling expenses to pursue their purchase based on a certain timeline. And then we come in and start looking at title and realize that these children, in fact, don't even own the property. In this case that I'm actually speaking of, Candice stepped in very quickly. And so do you mind just sharing a little bit of the details and how long the process took? This one was in Massachusetts.
Sure. So it depends really on the court that you're dealing with and also their current sort of pipeline that's in front of you when you submit an application for a petition for a probate to be opened and someone to be appointed with the authority as executor or personal representative to handle the sale. In this case, we had a situation where probate had not even been initiated yet. So this was really worst case scenario, unfortunately. We were starting from ground zero. It took several weeks. We were lucky that we had a friendly clerk at the court who helped us move things through, I think, faster than it would even typically go. But absolutely, the closing was delayed by several weeks. Nobody was happy. We were fortunate in this case that we had a buyer willing to be patient.
Yes.
But that's not a guarantee and not always the case. And so what happens is until someone is appointed as executor or personal representative, no one has authority to sell the property. And then depending on what state you're in, whether you had a will or not, and what the will says, you may also have to get a license to sell, which is another step in the process. So this is why in the case that Jackie and I are referring to, that process took several weeks from start to finish. And when I say start to finish, I mean just in terms of having someone have the authority to execute the sale, but now the family still has to go through the rest of the probate process, which will likely take until the completion of a year.
And it's expensive, isn't it?
It's
costly.
It is. So the cost of a probate in almost all cases is far more expensive than the cost would have been to set up a revocable trust. And cost aside, the hassle that you're leaving for your loved ones is sort of immeasurable versus when someone is trying to sell a property in a trust. But yes, several $1,000s typically to see a probate administration through from start to finish.
It's interesting. We just had another issue where the son of the individual that passed away thought that he could just enter the property and sell it immediately, and really didn't. And he was, in fact, expecting on the liquidity, the money from that real estate sale, and didn't know until he met with Candice that unfortunately he couldn't proceed with doing that until he handled the probate, which is going to take some time and some filing fees. So this is a perfect example of where real estate and estate planning converge, and we like to stay ahead of these issues. We are happy to meet with clients on a complimentary basis for a consultation, and then we'll put a plan in place so that we can avoid some of these things.
That's right. So if you have someone who has passed away that is on title for a property that you're looking to sell, the best practice is absolutely to initiate that probate proceeding before the property is ever brought to market. And that's what we would be here to help you through. And then once we have the appropriate authority in place, the real estate portion or team can take over.
So where real estate and estate planning converge, it's real planning, and we'd love to help you get there.